Hi, I'm Louise Nixon. I'm co-founder and CEO of Quadro Counsel. I'm president of Quadro Benefits Law Group. I've been involved in pension division and Quadros since 1994. I've represented retirement plans and also the parties throughout those years. Today we're going to talk about two California plans, CalPERS and CalSTERS. What are the most important things to know? We'll cover plan information, what's needed to divide these plans, what are the major issues surrounding the plans between an active member and a retired member, the best way to divide these plans, and lastly, how to preserve and protect survivor benefits if it's possible. So let's just start with California plans in general to get you an overview of what we're dealing with. There are different types of state public plans. So you've got city, municipal, state employees. Those are generally all CalPERS. Some of the larger cities have their own plans, but generally it's CalPERS. There's also judges. They have a judicial retirement system, and that is administered by CalPERS. And then teachers contract with CalSTERS, and county employees generally have their own retirement plans, only retirement systems. There's almost always two plans, a defined benefit plan and a defined contribution plan. And often one of those two plans is omitted. Generally, state, county, city defined benefit plans are divided by the marital fraction using a shared interest method for the domestic relations order. And then some plans offer a division by what's called a segregation method for an active employee. And for example, PERS and STERS, which are the two largest retirement plans, state retirement plans in the state, they do allow the segregation method. And survivor benefits differ depending on the division method that is selected. And back to the omitted plans, the one of the two plans that's omitted, I would say for state public plans, the plan that is often missed is the defined contribution plan, is the 457 plan or the 403B plan, either because the parties think that those are all part of PERS and or STERS, or they're just not aware of it because it wasn't disclosed. But it's something to look for, especially for either side, but especially to ask your client whether he's the participant or if it's the non-member to do some little bit of work into it, because most of them do have these other plans and they're often left out of the divorce judgment. When they come to us post-judgment, that's when we ask them about it, and that's when it turns up. So it'd be great if you can figure that out beforehand and make sure that nothing is left on the table. So let's talk about CalSTERS first. It's the state teachers retirement system. There's one in every state. This is the website for the California for CalSTERS. Pre-retirement choices. You've got the shared payment at the member's retirement date, or they can segregate the service credits accumulated between date of marriage and date of separation. So under California law, the non-member spouse gets to decide the form of the division. CalSTERS will provide an estimate of marital property interest, which is great because they'll actually say, if you give them the date, you give them the basic information, they will say if the member retires on this date, non-member will get X amount under shared interest and X amount under separate interest. So there's a very clear understanding based on an estimate of when the member is going to retire and an estimate of future earnings for you to work with. Quadro Counsel can help you with that, obviously, as well. And the factors that you want to consider, which we'll go through for both CalSTERS and CalPERS, is the age and the health of the parties, the length of marriage, the length of employment, the salary at date of separation, which I'll talk about in the coming slides, and the anticipated date of the member's retirement. So for the separate interest method, let's dive deep into that for a few moments. Again, that's pre-retirement only. You can't do segregation if the member's already retired and getting a monthly benefit. The benefit for the non-member is calculated based on the member's final average compensation at date of separation. So so that's important to know in terms of making a decision, because if the date of separation was a long time ago, the non-member may not want to choose the separate interest model, may want to wait for the member to retire and do the shared interest model. If the member is not vested, and they vest after 5 years of work, if the member's not vested at the date of separation, then the non-member will only receive a refund of contributions plus earnings on those contributions with a separate interest DRO. If the member is vested at the date of separation, then the non-member can still elect a refund of contributions and earnings, or the non-member can elect to receive a monthly benefit when the non-member reaches age 55. So we found that if there's a refund of contribution selected, it's generally because it's a very short marriage, or because they don't want to wait till age 55, so they're young, short marriage, or they have no choice because they weren't vested at date of separation. Under the shared interest method, on the member's retirement, the non-member receives a monthly benefit based on the marital fraction, on the time rule formula. So again, shared interest can be used for pre-retirement, but it must be used for post-retirement. For post-retirement, for CalSTERS, you can change any option for survivor benefits that's selected, so long as there was already an option selected at retirement. So if no option was selected and the unmodified was paid, then you can't change to an option. But if there is an option selected, you can change to another option. I'm telling you that so you know that's an option, but I would say that most people keep the option already selected due to cost, because the cost of switching to the compound option, which is what is elected generally in divorce pre-retirement, is a lot higher than a lot of times the cost that was originally selected for, say, 100% option selected at retirement. The segregation method is, again, these are tips to choose which one to choose, to which one to select. If the non-member's age 55 and the member's still working, and the non-member doesn't think the member's going to retire and for many years and wants to start getting the funds now. The other is if the member's left work and is not going to return, so the amount is never going to increase in terms of waiting for the shared interest, and so why not start receiving the funds now? Short marriages and you want a refund of contributions, another reason for a segregation method. Or if the member dies before the member's eligible to retire, the segregation method will allow payments to be paid monthly over the non-member's lifetime. So that would be a reason to switch or to choose the segregation method if the member's not doing too well. But also, we have in all of our orders for the shared interest method that if the member dies before the benefits start, that the non-member can go back to court and switch to the segregation method, so there is a lifetime benefit payable. Otherwise, there's no funds payable other than a refund of contributions to the non-member. The shared interest method is most often selected when, because the non-member wants to wait until the member retires to receive any post-separation increases. post-separation, which could be significant if the parties are young and they want to wait and hope that the member will continue working and they'll receive an increased benefit at a later time. Another reason that the shared interest is selected is that the non-member is receiving support and receiving more in support than they would get from the pension, which is usually a lot of times could be the case. And so many times in the divorce judgment language, support will go away once the non-member starts receiving the pension. And so that would be a reason to wait until the member retires and use the shared interest. If the non-member is younger than age 55 and the member is still working and about to retire, then it wouldn't make sense to do the separate interest because the non-member can start getting his or her share when the member retires right now. So these are all factors to consider, and you have to look at the individual case, the length of employment, the health, the age, support, remarriage, all those factors are pulled into it. But it's really helpful to know that you can get an actual estimate from CalSTERS that will give you a breakdown based on estimated retirement dates. So let's talk about CalPERS, which is the Public Employees Retirement System. There's the website. And same choices, but so share payment at members' retirement date or segregate the accounts. But there are some differences between CalPERS and CalSTERS that are going to be highlighted here. So again, non-member gets to decide which one to choose. CalPERS will not provide an estimate of the marital property interest. Quadro Council can do that. We can do that for you, but you will not get it from CalPERS. Again, factors to consider: age, health, length of marriage, length of employment, and the salary at date of the divorce judgment. This is different than STERS, which is the date of separation, the salary date of separation, and the anticipated date of members' retirement. So separate interest, pre-retirement only. And the benefit is calculated for the non-member based on the member's final average compensation at the date of divorce. So if the member is not vested, I mean that's important to know. It's because I'm dealing with the case right now where the divorce isn't finalized and the parties are over 50 and it's a close call. They may want a separate account. They may want the shared interest, but because the value at date of divorce is going to be current, they may want to start it now and do the separate interest rather than wait for the member to retire. If the member is not vested after 5 years of service credit, the vesting is based on whether they're vested at the date of divorce. Then the non-member only receives a refund of contributions. If the member is vested at the date of divorce, then the non-member can elect either a refund of contributions or receive a monthly benefit paid over the non-member's lifetime. But the start date that the non-member would be eligible to receive the monthly benefit is once the member and the non-member both are at least age 50. With the shared interest method, the non-member receives monthly benefit based on the marital fraction. Again, it's an option for pre-retirement and it must be used for post-retirement. If it's used pre-retirement, then the option that is selected for divorce is called option 4. Option 4 will ensure that the non-member receives the same amount for the rest of his or her life. The non-member will pay for the costs generally, and because the non-member is getting the benefit of the option, in return, if the non-member dies before benefits start, generally the non-member's share will be paid to non-members' beneficiaries. For post-retirement, you can only change the option to unmodified if the member is awarded 100% of the benefit. Otherwise, you're stuck with whatever option was selected at retirement. And we'll talk a little bit later on the impact of that and what people decide to do, because it's usually dealing with a survivor benefit issue. The issues come up with option 2, 2W, 3, 3W, with post-retirement. But we'll get that into that in a minute when we discuss survivor benefits. So here again, some tips to look at and try and figure out which method to choose. If non-member and member are both age 50 or older, member is still working and doesn't look like it's going to retire anytime soon, the non-member may want to start receiving the funds as soon as possible. If the member has left work and is not expected to return, then segregation method might make the most sense. It would make the most sense because there's if as long as they're eligible to start the benefit, then once they're eligible, they will get it, and there's going to be no increase in value to stay on and wait for the member to retire. Another reason, again, short marriage and no member wants a refund of contributions now, and also if the member dies before eligible to retire. The shared interest method is most often selected when the non-member wants to wait for the member to retire because the potential salary increase will be substantial or worth it to wait and get a larger share at a later time. The other issue we just talked about with CalSTERS is if the non-member is receiving support. They may not want to stop receiving that support because it's more money than they would get with a segregation method. And if the non-member is younger than age 50 and the member is about to retire or is still working and the non-member wants to wait, but those are all factors to consider, especially if the member is about to retire, non-member is younger than age 50, it would make sense to do the shared interest because then the non-member can start receiving his or her share when member retires. Again, you got to look at all the factors between the parties to weigh the factors and decide which method the non-member wants to go with. But again, the law is very clear that the non-member gets to choose between the shared interest and the separate interest. So I'm going to take a moment to analyze the most common mistake that's done with CalPERS. And I think this is really important, and it applies to other plans where they've just identified contributions. So we'll talk about that in a minute. So here's a CalPERS example. The husband is a CalPERS member and is considering a buyout of the wife's interest in the pension. So what steps are required? So number one, you can calculate the monthly benefit under PERS. To try and consider a buyout, and then come out with what the actuarial present value is of the community interest. So you can compare those two and decide if it's worth it to do the present value buyout of the wife's shares. Sometimes it is worth it. Sometimes the parties are looking at this and saying, my wife wants the house and the husband wants the pension, and it makes sense. But the present day value of a CalPERS pension is significant. And so many times the parties go through this exercise, come up with what the present day value is, only to realize that they can't possibly afford the buyout. Some CalPERS members in particular, they just want to know. They want to know what the estimated monthly benefit is, and they want to know the present value. And Quadro Council can do all those calculations for you. So if there's no buyout determined, then the parties have to decide between Model A, which is the separate account, or Model B, which is the shared account, and draft the Quadro. So I'm going to go through an area that I think is really important for attorneys, any divorce professional to know about in terms of statements that the public employee gets that show the contributions that the employee has made to the plan. And that is not the total value of the pension. So what's written in circles and boxes, that's what I've added to this form. This is not on the form. What is on the form has been highlighted. So let's go through this so that you can understand, and I'll give you an example of what happens in terms of malpractice that in a minute. So in this case, for this particular participant, the employee contributions are approximately $167,000. Okay, that's what the employee has paid out of his or her paycheck to the retirement plan. The vast majority value of the pension is paid by the state of California, and it's only paid in the form of a monthly benefit over the member's lifetime. So this $167,000 is what PERS will pay if there's some sort of refund of contribution that's made to the member or to the spouse or former spouse. The calculation of the monthly benefit, which Quadro Council can help you with, this is an estimate of what the monthly benefit would be based on that $167,000 contribution and the age of the member. This is obviously, it's not on the statement, but this is what the monthly benefit would be. So it sometimes might be a good idea, and the member wants to know what the estimate for the monthly benefit would be. But the bottom value is the most important value to understand. That is the actuarial present day value of the pension, $1.14 million. So that's quite a difference than in terms of the value of the employee contributions through the present date. And where this comes in and where we see problems is, and we see it pre-judgment and post-judgment, but if we can catch it pre-judgment, we can help the parties. But what we see is offsets being done with where one party, the former spouse, has let's say a 401k worth $200,000, and the member has contributions to CalPERS worth $167,000. What we see, and we see this a lot, and other Quadro professionals do as well, the parties offsetting $167,000 against the $200,000. And obviously that's malpractice, that's inaccurate, because that's just the value of the employee contribution. The value of the pension is $1.14 million. So if they're going to do an offset, it needs to be against $1.14 million, not $167,000. In the particular case I'm thinking of, it happened not too long ago where this matter came up, and luckily the parties, the attorneys in the case, sent us a draft of the judgment that did an equalization and offset based on employee contributions against the former spouse's 401k. And I had to red flag it. I let them know, do go forward with this. And then we did a present value, which obviously ended in a different sort of negotiation between the parties. If Quadro Council does a valuation of benefits, this is what the statement would look like. This is what you would receive to understand what the value of the pension is, the monthly benefit, and what the total present day value is. This is an actuarial valuation. So we have these reports that can help you understand what you're dealing with CalPERS if you're contemplating some sort of equalization and offset. So again, most CalPERS and CalSTERS employees have defined contribution plans. They have a 457. Most CalPERS employees have 457 plans. Most teachers have a 403B plan, which is also known as a tax-sheltered annuity. The things to watch out for these TSAs are surrender charges, and depending on the product that the member is signed up for with a particular TSA, there could be surrender charges that one or both parties will need to incur when the funds are transferred. Most of the time, surrender charges are not incurred in a divorce with a DRO, but I have seen some TSAs where they are incurred, and it's important to understand this possible allocation and who it should be charged to, whether it's split equally between the parties or the participant pays or the former spouse pays. The other issue with the TSAs is that if the member is in pay status and there's a TSA, they may have selected it to be paid as a monthly annuity. And in that case, the quadro would be different than a quadro for a 403B, which is generally treated as a defined contribution plan. The funds for both these plans are held by an outside vendor. They're not held by CalPERS or CalSTERS. And their employees. So most of the times you're dealing with outside vendors like Nationwide, they're a big one, and you will need a quadro. So let's take a moment to talk about survivor benefits for California plans. I'm going to cite some cases, some lead cases. One is marriage of Kramer in California. Once a post-retirement dissolution occurs, the non-member can no longer qualify as the surviving spouse of the member. There are the exceptions under LACER, STERS, and some of the 37 county plans, but this is important to know because it could be that there is no survivor benefit payable to a divorced former spouse. There's a possible loss of survivor benefits with a shared interest plan with some of the plans that I'll go into that in a minute. And this is another malpractice area that I think is really important to know about. If the member retired before divorced and then divorced and then died, there are no survivor benefits payable for the non-member spouse. For any, even if the employee remarried after they retired, there would be no survivor benefits payable. So that's a big issue if you're contemplating and the parties are thinking, well, I'll still get the survivor benefit, or they refer to it as a survivor continuance, even after divorce. And you won't because of the restrictions on the law because of marriage of Kramer. So for the workaround for that is if the parties are willing to, because they want to ensure survivor benefits, is a legal separation. That's probably the biggest and most common workaround. So with the legal separation, this issue has been litigated. I was actually part of an amicus brief to try and move it along in the favor of allowing legal separation to continue qualifying for a survivor continuance. So this case actually confirmed that if the parties are legally separated, that there will be the survivor continuance payable. And if the member insists on a divorce, then the parties would probably want to look at other forms of compensation, such as life insurance. I would say that's the second most common situation where they try and get some sort of life insurance to benefit the former spouse in the event of death. The one thing it's important to know, this is generally applied in county public plans throughout the state of California, this area of law with Kramer, because in the other areas of law, most of the time you can get some sort of survivor benefit with an option selection. But for these county plans, for the most part, and I'm being very general here for a reason because there are nuances with different plans, different county plans, there's this survivor continuance, and the survivor continuance in most cases is a free survivor benefit. That means there's no cost for the plan to pay the benefit based on the life of the member and the life of the spouse. So they're basing a payment based on 2 lives, and for the most part, the percentage that's awarded for the life of the former spouse, or not the former spouse, for the life of the spouse in the event the death of the member, after member retires, is 65% of what the member was getting as a retired member. So it's a huge benefit, and that's lost in the event of divorce. I had one case that I'll never forget because the parties spent a lot of time and a lot of money in the divorce action. The doctor. The member was a highly paid salaried doctor for the County of Los Angeles, and the parties were close to 80 getting a divorce. And I think that this case came to me post-judgment, and I had to break the news to them that there was no survivor continuance that would be paid to the ex because of the divorce. And I do believe, had they known from their legal counsel beforehand that they could do a legal separation to preserve that interest, that they would have done it. Unfortunately, for that particular case, it was too late, and the member was not willing to undo the divorce and change to a legal separation. So that's where it shows up in terms of liability for the divorce, for the family law attorney or divorce professional to really think this through to ensure that the parties are going to get that survivor benefit. There is some case law in California on when to compensate for the loss of a survivor benefit. So you have marriage of nice, which is a good case to know about, where the court actually held that the member should be compensated for the community value of any lost survivor benefit. And then in this marriage of weight, there's an analysis that's done, and in marriage of weight, which is not usually agreed to or enforced by the court because it just results in a very unfair division based on too much uncertainty in the case of when each party is going to live or die. But if there is a lost survivor benefit in weight, they actually awarded a larger share of the benefit to the former spouse for the member's lifetime to compensate for that lost survivor benefit. And I have seen some cases where that has been done, but I would say most people are able to, if quoted, they use nice and say, well, the member needs to be compensated for this value. And most of the time they try and get the compensation out of some other asset, and in particular in life insurance, if it's at all possible. Another lead case in California is marriage of Carnell. And that case basically held that the former spouse can be awarded a portion of the survivor spouse's benefit, which would terminate when the surviving spouse dies. But at least in the situation where there would be no survivor benefit payable, if there is a former spouse, if there is a current spouse that is married to the member at the date of death and survivor benefits would be payable to that current spouse, the DRO would be drafted so that the former spouse would get the benefit of whatever the marital interest is, whatever percentages of that continuation benefit that's being paid to the surviving spouse. One plan that we see that a lot in is the City of Los Angeles Fire and Police, because that's the only option for a lifetime benefit or a continuation benefit to the former spouse in the event of the member's death. And then there's this line of cases that deals with what happens when the survivor benefit exceeds the marital interest. And which of these cases apply depends on the facts of the case. So we're going to go through each one so you can have a better understanding of them. And then if you happen to get a case that this situation comes up, you can hopefully look back on these PowerPoints and try and understand and figure out which way to go. So for the first case is marriage of Cooper. And in this case, the court actually ordered the member to buy out the non-member's spouse's share, because the community interest was so small. In that case, I think they were married for only 2 or 3 years. The member was very in love and a lot older than younger woman, and elected the 100% option for CalPERS, which results in a significant reduction in the monthly benefit that would be paid to the member. So the court ordered this offset, this buyout. So the parties went through the process. They actuarially valued the member's benefit for the community property interest, including the survivor benefit value. And then the former spouse received those funds from some other asset. And then the member then was awarded 100% of the CalPERS pension, which allowed the member to undo that survivor benefit election and resulted in a larger monthly unmodified benefit. The second fact pattern is this case Sonnet, which is a big case in California for many different reasons, but for purposes of this this survivor benefit issue, this appellate case is the one that you need to look at. It actually went to the Supreme Court on another matter that we're not talking about today, but most important is this appellate decision. And in that case, the court found that the value of the survivor benefit far exceeded the value of the cost to the member and the non-member. So it wasn't fair to the member. It wasn't a fair enough. It wasn't fair for the former spouse to just pay the cost, because the value of the survivor benefit was 100% of the pension if the former spouse, if the member died before the former spouse. I think, as I recall, the value of that is awarded was the marital property was about 24%. So it wasn't a huge value, but it was not the same very minimal value of the marital property interest that was stated in Cooper. So the holding went through Cooper and said, well, that's not fair because the non-member couldn't possibly, it was too large an amount to buy out the non-member, and it was too uncertain. They went through an analysis of that as well. But the holding the conclusion they came to is, we're going to keep the options the same. We're not going to change this 100% option, but the parties were ordered to set up a constructive trust to be applied. So if the member happened to die before the non-member spouse, then the non-member, the former spouse, would receive the funds, because it could only be paid, all those funds can only be paid to the former spouse 100%, but that would be held in trust, and then the former spouse would get his or her marital fraction share, her time rule share, and then the rest would be paid to the beneficiaries that the member had allocated in the trust. So this is it makes sense. It's a good analysis to deal with this, kick the can down the road, deal with this at a later time. The only problem is that CalPERS is not involved with a constructive trust. They don't oversee it. There's issues with their tax issues. There's enforcement issues for down the road, how this can be enforced, who's going to enforce it. In many cases, it is not a realistic resolution of the matter, and a lot of parties don't want to deal with that level of uncertainty. So they'll reach some sort of compromise, which I'll talk about in a minute. But I have seen it done, and I have seen the cases where it is left, because what happens if the non-member dies first? Then any sort of buyout would not be necessarily be fair, and there wouldn't be the need for the constructive trust. The third survivor benefit case that deals with marital interest and exceeding the value of the community interest is Marriage of Smith. That's actually a military case, so if you watch my military talk, there you would see reference to Smith. But in that approach, they apportioned the survivor benefits, and they did it based on cost. So they looked at what both the member and the non-member should pay for the cost, due to the fact that the member's benefits statutorily reverted to the member upon member's death. So what that means is that if the non-member died before the non-member's share, whatever percentage it is allocated to the member, goes back to the member. So the non-member gets the bump up of 100% of the pension. The member gets the bump up of 100% of the pension. The non-member, in that case, gets the allocation based on the marital interest. And the court said it's not fair for the member to not pay any of the cost of the survivor benefit when they're getting the potential benefit of receiving 100% of the pension in the event of non-member's death. So that case grappled with that. They came up with a formula and a way to handle that division. But the general concept of Smith can be applied to any of the public plans in California in terms of trying to come up with something, some sort of resolution that the parties could deal with and move forward in their lives at post-divorce. What we do see happen and where Smith is applied is in particular is if let's say the CalPERS, I'm just using CalPERS as an example, retired and selected the 100% option. And it's a long-term marriage, so the percentage that's awarded to the non-member spouse is substantial. So parties generally agree to just leave it alone. If the member dies first, the non-member share bumps up to 100%. If the non-member dies first, then the parties agree that non-member share is then reverts back to the participant, to the member. So the member gets 100%. So both of them, by leaving it alone, splitting the cost 50-50, both gets the potential of an increase in community property if the other party dies. And I would say, just in practice, that's what happens in the majority of cases. But again, we have these other cases that can help you if your fact pattern is close to the fact patterns in those cases, and the parties are able to. And I mean, if it goes to court, then the court's going to obviously look at the cases of Cooper and Sonnet to make a determination of how to proceed. So for judgment language, the most important thing you need to know before you write the judgment, I mean, in a perfect world, I would love to see all these issues, all the pension issues resolved before judgment. That's the best case scenario. Unfortunately, that's not the reality we live in. That's not what happens in a lot of cases, in most cases. So if you can just for sure find out if the member's retired or not, because that will be a trigger for all these survivor benefit issues that could blow up post-judgment. So you don't want it to blow up post-judgment. So if the member's retired, I would say stay in the case until this issue is resolved, because it could come back to haunt you afterwards because of these issues that have to be dealt with. I would say also keep the award for state public plans very general, because I see in divorce judgments marital fraction applied to everything. Time rule applied to defined contribution plans, defined benefit plans, state public plans, all of it. And you don't want to do that, and for a lot of reasons for all the plans. There's no one-size-fits-all award. But if you do have the marital fraction listed in the judgment for a CalPERS or CalSTERS plan, that marital fraction can only be applied if it's a shared interest quadro. So if the member is still working, is not retired, the non-member spouse may want to choose the separation of account method. That may be a better deal actually for both parties in many cases because of the cost involved with choosing an option under a shared interest quadro. So by leaving it very general in your award in the judgment language when it comes to CalSTERS and CalPERS benefit, you're doing your clients a favor if you haven't dealt with the how they're going to choose, which method they're going to choose, because then they can choose what they want, and there won't the non-member can choose in particular. So they can choose what's in their best interests. We have seen cases where the marital fraction is awarded, but it is in the best interest of the non-member to choose the separate interest. They want to start it now. Many times it's fixable because the participant says, "Fine, I'm fine. I'll agree to that," but the fact is that this is all happening post-judgment. They're thinking, why wasn't this all dealt with pre-judgment? And if the court looked at this, then they would also have to explain it to the court, because obviously the separation of account method is not the marital fraction. That's not the same way of dividing. So Just important to know. And then if the member is retired, you really, again, like I said, if the member's retired, you've got to deal with the survivor benefit issue before you draft the judgment language, because I've had to go to court. I know a lot of other people who do what I do. There are not that many of us, so the few other people I know that do quadros on a regular basis had to go. I've gone as an expert, and I've had to testify about all these factors, and it's not fun to do that, and the expense to re-engage the divorce professionals in the case, it adds up. And all of these issues maybe could have been resolved pre-judgment, and maybe would have been less costly for the parties. So in terms of final thoughts, we'll just always include the survivor benefit award if it applies. Also, I would say, aside from doing the joinders, which you have to do, and we discussed that previously in the basics, do the joinders. But if you get the divorce judgment, go ahead and send that to CalPERS and CalSTERS. It can't hurt in terms of placing a hold and alerting them that the quadro is coming. And again, I encourage you to do all this pre-judgment work to stop the post-judgment problems. And here's some basic information on how to contact us. And thank you for joining me today. Thank you.